Welcome to the Eversheds Sutherland Inquiries and Inquests podcast. I'm Isabelle Mitchell and I'm a partner in Eversheds Sutherland's Public Inquiries and Investigations team. Today's episode is titled, What Does Trauma-Informed Really Mean? And I'm joined by Rachel Spearing KC in this episode, a leading barrister at Serjeants Inn Chambers, specialising in inquests, inquiries, public and policing law. She had a broad common law practice before joining Serjeants Inn, which included sabbaticals to co-found and lead the Wellbeing at the Bar initiative with the General Counsel of the Bar. Rachel has operated for many years with a trauma-informed approach for safeguarding herself and her clients in practice. And we recently worked together on the high-profile Bar Standards Board case concerning Joe Sidhu KC, where we represented pro bono the relevant complainants in that case. In this episode, Rachel and I discuss what using a trauma-informed approach really means in practice and its importance when setting up processes, taking evidence from witnesses or representing clients in inquiries, inquests, investigations and other relevant proceedings, where the subject matter is often sensitive and the risk of trauma or re-trauma arises. We consider the different aspects of a trauma-informed approach, how that can be achieved, and the long-term benefits it can bring. We hope you enjoy. Hi, Rachel. A huge thank you for being with us today. And as you know, our particular topic for discussion is about adopting a trauma-informed approach to inquiries, inquests and investigations work, something that has always been important and present in both of our areas of practice, and I think something that is more readily acknowledged as being critical to this area of work, certainly more than it has been in the past. Personally, from a career perspective, I first experienced how trauma can affect individuals in judicial processes right at the beginning of my career. When taking evidence from individuals that were applying for non-molestation orders in family proceedings. And then when I joined Eversheds in 2008, working on inquiries, gathering evidence from traumatised soldiers, victims and families of poor medical practice, whistleblowers, abuse victims, and many others who have experience of tragic events or issues that have left them with scars and marks of trauma. But it'd be really good just to kick us off, Rachel, talk to me a little bit about your own experience of dealing with trauma in inquiries, inquests, investigations, as well as, you know, representing clients or taking evidence, and how that's featured in your career to date.
So Izzy, thanks so much for inviting me to come and speak about this topic. You will know that this is a really important subject for me. I first encountered the issue of what is or what was a trauma-informed practice a long time ago, when I was a rape and serious sexual offences prosecutor in the Western Circuit, which would have been 12, 15 years ago. And I started to undertake some voluntary work around that and spent time in the SARC, which was the Sexual Assault Referral Centre. And that brought me into contact with some clinical psychologists and support workers, the independent sexual violence advisors, and other volunteers who really helped me see the impact of individuals trying to speak about difficult experiences and understand my role, who was someone at that time who was trying to achieve best evidence and may be involved in presenting factual information. And so the early work that I did in what was essentially a voluntary experience really fed into my work as a very young barrister at that time, taking the first steps to present in the Wessex prosecution work around the circuit. And that evolved really, that my learning, and fed into the Wellbeing at the Bar work that I did with the General Counsel of the Bar, just to understand that, in fact, working with people and being around individuals who have suffered trauma isn't just confined to those who are the victims or the witnesses to domestic abuse. It can have a very, very wide perspective as to how it may touch people's lives. And it is very, very important to have a really focused view of client care and teamwork when we're providing services in inquest inquiries and investigations. But it also matters for us too. And I think we're going to come on to looking at how this subject can develop and also touch those who are working with these difficult subject matters sometimes.
Okay, thank you. And of course, the clients or witnesses that we have both come across during our careers have all been very different. They all have different characteristics and factors to take into account when representing them or taking evidence from them. And I think, I mean, my own view, and correct me if you think differently, is that a one-size-fits-all approach doesn't work because of those really varied characteristics and factors. But there are some common concepts and best practice for carrying out this sort of work in a trauma-informed way, and also looking at what negatively impacts individuals that are involved in legal proceedings, whatever form they may take. And so I wondered if, during the episode today, we can look at some of those common concepts. But before we do that, one of the things I wanted to start with is really the aim of a trauma-informed approach. Recognizing this being about recognizing the impact of trauma, being able to practice in a way that does no further harm, minimizing the risk of re-traumatization. But what I was keen to ask you about is your understanding of what the benefits are and what those can bring when adopting a truly trauma-informed approach in this work.
Well, it's interesting because for me, and some of those very early experiences were encountering what I would describe as a really suboptimal functioning of the criminal justice system, where an individual who had suffered a very difficult experience was not always fairly and properly treated. So for me, at the heart of this, it's about being having equality and fairness and justice, and that, I agree, does mean that there isn't a one size fits all approach, and there isn't a magic bullet here that we can. We will talk about some of the approaches that have been written about and some of the best practice guidance that clinicians and professionals have supported us in our understanding with. But my foundations of how I want to operate are to ensure that those we're seeking to engage with or where we're trying to interact, we're looking at ensuring that they can be accommodated to protect what they need to share, and also to empower them to do so in a proper way. They are also some of the individuals who, whether they're a witness or whether they're a whistleblower or whether they're a person who is responding to an allegation, there may be an element of violation of their rights, whichever side they may sit. So these harmful events, or these events that we are seeking to understand and to probe and to investigate, can really have profound impact upon people's lives. And so we must ensure that we tread respectfully, carefully, to ensure that we are able to communicate or engage with them in a way that tries to seek to do justice in how we are doing our jobs and discharge, obviously, our terms of reference, or facilitate the support to the inquiry as we're expected to do so. But we're really trying to make sure that we conduct impact assessments, we consider our planning, we look at how we may be able to put those practices or best practices into place. So we're preparing ourselves, we're recognizing needs of individuals across a wide spectrum. We're considering how we're going to onboard these issues, whether that's within our own team, or whether that's within the organizations that we're going to step into. And we're looking at informing choices. So talking to individuals about what needs and what explanations we need to have around some of the topics to help people engage with us. So looking at the best strategies for that.
Okay. And the way that I sometimes look at a trauma-informed approach, or where particularly when I'm trying to sell it to, junior colleagues as an important part, a really important part of practice, forget the legal work, actually, this is a fundamental sort of basis for the sort of work that we do, is that there are, it benefits those that are impacted by trauma, but also there is a benefit to legal teams in terms of the quality of the evidence that you get, the quality of the relationships that you can establish with either your clients, depending on who your client is, or indeed sort of witness engagement, stakeholder engagement. Would you agree that that is a tangible benefit from this sort of approach?
Absolutely. For the clients or witnesses in an inquiry or an investigation, they want to be treated compassionately and be supported through the process too. And so taking this approach can really positively influence their experience of the process itself. And it can lead to better engagement, it can lead to trust, it can influence their experience of the process, and it can ultimately help with their support and management through a safer way. And if we consider some of the recovery aspects of this, whether these are our clients or whether they are individuals who are subject to an inquiry themselves, they want to feel that they have had a fairness and due process to that. So it enables them to have legitimacy and an understanding of how they will be treated in an advanced way. And for legal teams, that effective engagement can have a really positive impact on the quality of information they get and prevent sometimes some of the stressful scenarios of where our colleagues are trying to follow advice or to act upon the guidance and instructions we're giving them. So they are hopefully minimalising the impact to the clients, and they are, I would hope, also reinforcing the trauma-informed awareness for themselves too, to give them key protections in how we approach that. Okay.
If I can just move us on a bit to, I guess, the key principles of what is a trauma-informed approach. It's a word that lots of people use, but what it looks like in practice will mean different things to different people. And so I just thought that we could explore that a bit. And I have tried to kind of split it out into three key principles. The first is safety, so physical and emotional safety. Next is trust, building trust through communication and transparency. And then third is choice, so about autonomy and empowerment. And I just thought we could take each of those in turn. So the first, safety, physical and emotional. This, I guess, being the basic framework for how you would set up that relationship with your client or your witness, meeting those most basic of needs. And in order to do that, you have to have an understanding of, in inverted commas, vulnerabilities or characteristics of the individual that you are dealing with. So talk to me about what would be your starting point for trying to establish this framework that enables a safe environment, both physically and emotionally, for an individual.
So understanding vulnerabilities, I have an issue sometimes with using the word vulnerability. Understanding vulnerabilities may not always be obvious, and the reason for that is we talk about a vulnerable witness, And in our mind, we're often drawn back to vulnerable witness training, where we think about the issues that may affect a vulnerable witness having experienced sexual or physical trauma or violence. But in fact, a person may be vulnerable per se just by reason of the proceedings that they find themselves engaged with. So it's not always obvious, and they may not always want to reveal or speak of their own vulnerabilities. So developing trusted relationships takes some time. Thinking about physical safety and thinking about developing physical and emotional safety is quite a complex area. And so to start with, I would always give an indication that we are operating per se with a trauma-informed process. I would explain what a trauma-informed process is, that it means adapting the situations, the meetings, the conversations, putting support services in place and signposting people to what those services or that assistance is, being mindful of what my role or what the boundaries for that role is as an advocate, and having other professionals who may be better placed to help individuals or to provide more information about the issues that we might be dealing with as part of our investigation or our review. So what does that look like in practice? It's just about thinking about the planning. It's about thinking of having potentially independent support and services around that. There might be internal support and services that are available. It might be having certain members of the team who may be in a certain type of sexual inquiry may be better placed to be female, or maybe locations as to where and how you might meet somebody, the timing of those meetings, or all the triggers. Having supportive, present individuals. Sometimes in policing investigations, there may be federation representatives, there may be other representatives, friends, associates, colleagues. It's just making individuals aware that you're not going to expose them to feeling vulnerable. And so a person may not be vulnerable per se, but they may feel vulnerable by reason of where they've actually got to come and engage with you as part of that work. So thinking about your environments, being clear in how that emotional safety is going to work, where a person may be threatened. And of course, threat and the perception of that threat can come in many, many forms. So it is not simply having a conversation about a difficult subject. It may be the process of and in itself where they may feel threatened or at risk by reason of their role, by reason of the subject that they've got to speak about, or others where they may be speaking about colleagues who are more senior than them, and where they may feel a sense of vulnerability and threat around speaking candidly about issues that they've witnessed. So it's really starting to just think about it to start with in practice, that very early recognizing, realizing the prevalence of what those issues might be, and recognizing the trauma that may arise given what you're asking questions about.
Yeah, I agree with all of that, and I think the key, I think, as you said at the beginning, was don't make assumptions about what may be important to create that environment for a person, and don't assume that from the first conversation with them everything that you need to. That it's got to be an ongoing communication with them. I think one of the things when I sort of reflect back on my experience is that often asking for feedback about whether they felt comfortable, if there's anything that could be done differently at the end of a meeting, if they want to, does this time work for you? Does this location work for you? Having that open door to make sure that it's not just something that's set up at the beginning, but is developed and embedded kind of throughout the course of that engagement with them. Because, we know that different things will be revealed along the way, which you won't have known at the beginning, and you definitely won't have known at meeting 1, 2, or 3. But as that, and we'll move on to the trust. That's quite a nice sort of move on to our next sort of principle. But until that is more established, you may find that you're just not going to be able to build that completely safe framework for some time.
Yeah, and we've got to remember that a reasonable adjustment is always best coming from the person who knows what their own needs are, and in reality may not be able to tell you at that time, but the fact that you're giving them the permission to tell you when they feel ready, or to communicate through another person. So it might be a specific point of contact that they wish to engage, to be able to have that capable guardian or a third person to be able to share through that conduit of what will work best for them. So this trust, it takes time, and it can only be established through clear communication, transparency, a feeling that is something that they can build on, and that where something has or is going to be difficult, they can take a step back and they know that you've got the adaptability to adjust the process. They feel that you care, actually, that they're not, that one size doesn't fit all. And if they've spoken to others and they're aware that you've adapted it and are more than happy to do that they are able to engage in what works for them. And that is really, really important in fundamentally establishing and starting to build that. And then over time, asking them what they need, or going back to them, most importantly, with consistency, telling them what will happen next. And even if there's nothing to report, going back to them with the fact that there is nothing to report, in whatever actions you've promised you'll take, or words that you've given them as part of that process. You are honouring that. You're consistent with it. You're demonstrating an empathy and awareness and openness in how you can keep that dialogue going. So when things are difficult, you can adapt the process, or you can speak to others to do the same as their needs arise.
Okay. So we kind of sort of moved on to our next principle around trust, about building that through clear communication and transparency. And I think we know that's not something instant, that particularly with trauma, establishing trust with individuals can be difficult. And you've just spoken there about some of the things that can help to build that relationship of trust around, regularly engaging with a person, being consistent with that, whether that's the same individual as your point of contact, and providing an update, whether it's there is no update, remaining in touch with them. Is there anything else in terms of building on that, establishing that trust around communication and transparency that would help others trying to adopt this trauma-formed approach?
I think one of the skills that I did as part of my own CPD was I went on an active listening course, because as advocates we're so programmed on download or transmit that we often don't know how to listen, and that is a skill that I have found really, really useful. And there are lots of places that offer the courses through active listening, Samaritans and other types of organizations. You can do CPD learning. You can find information online. You can even Google free resources that are available to participate in free. I have listened to some of the work that has been done by Caroline Bruce, who's the educator and clinical psychologist for NHS Scotland, where she talks about how professional relationships and communicating is really key. And so listening and active listening with individuals where they feel you are you're interviewing a person, which often in itself can be an important technique to have. But as part of that, you can set out your preparatory issues. You can think about where and how you're going to connect with a person. You can understand a little bit more about their needs before you meet with them. You can set out clearly how that interaction is going to work, how the interview will operate, where they're going to be, the fact they can have lots of breaks, the questions or the topics that you're going to cover, and where and how they can be supported as part of that and by whom. So you can really trying to not just avoid the re-traumatization, and sometimes it's very difficult because you have to ask them about difficult topics, but they are prepared for that. And they, as much as they're able to have some agency and some control, that for me is very, very important, to respect their privacy and to ensure that they understand and have confidentiality around where and how their information will be used, and how you are going to treat them as part of your process, so that they are not as anxious about this, and ask questions. The freedom to ask questions, so that you can, because you can't anticipate everything, but that you're openly engaging with them.
Yeah.
To say, what else can I help you with? What else do you want to know? That you're ensuring that you've got this dialogue with them. Yeah.
And I think particularly on the sort of confidentiality and privacy point, I think less so where they're your client, because, that's an automatic client confidentiality, but particularly where you're running a process, whether it's an investigation or an inquiry, where you are providing a witness or an individual with information about how their data is going to be used, not just at the point of collecting it, but what might happen to it afterwards, and doing that in such a way that it makes sense, because, GDPR helps us in that you've got to have a privacy notice, but lots of people do not understand the contents of a privacy notice. So doing it in a way that makes it, make sure that they understand it, make sure that they ask questions, make sure you know the answer to those questions that aren't sort of legal jargon about GDPR, but that just so that it's really simple, this is what's going to happen with your information. And if you can't necessarily give them a guarantee about who it's going to be shared with, say that this is who it may be shared with, and once we know, we will update you. Having so that they have got an answer to their question rather than leaving them hanging. I mean, certainly from my experience, if they've got some reassurance about how their information, which is usually pretty sensitive, is going to be treated, and they have some confidence in that, then that can make a world of difference in terms of just another part of that, building the trust.
Yeah. And also what we mustn't forget is that the courts are alive to the reality that achieving best evidence is the absolute core function of courts. And whether you're under the Inquiries Act, whether you're under the Coroners and Justice Act, or whether you're working within the civil procedure rules, there are processes for special measures, for anonymisation, for applications to be made, for ciphering, and for varying kinds of special measures, where you can set out the justification, the reasoning, and the impact for your application to achieve best evidence in the process that you're engaged with. So I think we need to remember that as much as we are often, subjected to some regimentality around terms of reference or being called participants, we can engage quite proactively with chairs. And if somebody else hasn't thought about it, it doesn't mean that we can't. And in fact, we should. This is what good looks like. This is how we want to prefer and present our information to you in the best way to ensure that our clients feel fully safe and informed and protected to engage with you. So I think it's really important that we are in this territory now where we proactively seek to engage, where others have not thought about those processes as perhaps much as they should.
And then, I mean, again, a lot of these three principles all cross over, but the third one is just around autonomy and empowerment,
Mm.
and really about empowering individuals during the process of giving evidence or involvement in ongoing proceedings, however that sort of manifests itself. I guess feeling like the process isn't happening to them, um, which sometimes can be harder to achieve than others. So just talk to me about how you can achieve that sense of an autonomy, with um, sort of balancing integrity of whatever processes they're involved with, and how much you're able to say or enable them to have some power in those processes. How do you achieve that?
So I think this is where, for me, understanding clinical psychology and the impact of brain science, where does fear come from?
Mm,
Where and how is somebody's amygdala hijacked when they feel that fight, flight, or fear aspect? And this, this is across the spectrum. We've all had, even as advocates, we've all had that absolute terror of whether it's doing the exam when your mind goes blank, or walking into a court with a terrifying judge, or frankly having to give evidence, as some of us have experienced ourselves, where you're asked questions, and you're worried that you won't know the answer, or particularly if you're in the Court of Appeal, it feels like that with three very clever people on the other end of it. So, we just need to go back to human behaviour, and to think about how much to create an autonomy and empowerment. We are really trying to give back and support control. We're trying to control, or learn to be out of control, which is one of the things as an advocate that I've worked around. Is if you put yourself in the shoes of your clients, and if you can often think about reciprocal experiences of this hijack as to where and how we've felt from time to time. So this comes back to learning to control, learning to sometimes just accept that you won't be able to control everything, but to manage what we can describe as the no surprises principle. So you are walking people to and through what is a completely terrifying and alien experience that we deal with, our courtrooms or our inquiry rooms, or that's our office. But you're trying to just notify people in advance of things happening, and doing what you absolutely can to minimize those surprises. So in an inquiry, you know that there's going to be Rule 10 processes of areas of questioning. It's a signposting to where they will be able to access and find that information. They will, of course, have a witness statement both in an inquest and an inquiry, or any other process. There will be documents. So it's taking as much of that fear and uncertainty away, and doing what you can to minimize the surprises. Sometimes it might be empowering a person to make decisions as to how they're going to give their evidence. What special measures might help them do that? Or do they want to be remote or online? Do they want to be behind screens? Do they need to be ciphered to enable them to feel safe if they're worried about what they're going to say? And so it's offering the choice back to them, really. Again, comes back to what we started with, is don't make assumptions that what you've done for one witness is going to work for another. Actually ask them, as much as you possibly can, to feel that they are in control, and that they have a sense of control about how they're going to be engaged in this, what works best for them, how they and who they want to be involved with supporting them, or with being present, or not, as the case may be. And again, talking to your team, we do this regularly in the work we've done together.
mm-hmm.
We sense check each other in a collaborative team working way, to look at how you can promote the decision making to do the best you can for people.
And just building on that about, promoting this approach with teams, reflecting on practice, checking each other, checking in with each other. I mean, I've seen examples of some resistance to trauma-informed approaches in the past. And we've talked about training and that being, a crucial part of this. Really interested in the kind of active listening training that you spoke about. How else can we encourage this approach as being, I guess, normalized? It's not touchy-feely. It's not sort of something that's only right for certain investigations, certain inquiries. How do we help others to see it as a positive approach that should become the norm?
I think, well, for me, I go back to 2015 when we started talking about well-being at the bar, and the naysayers who thought that was all touchy-feely, opening Pandora's box, and concern around the implications for that. I think this just goes back to basics of treating human beings as human beings. When I looked at the very early work I did as a RASO person prosecuting or defending, I read a really impactful report that was written by victim support, who talked about another assault and how a lot of these experiences are really harmful to people. And that is not just victims who are talking about sexual violence. That is any individual, whether they are a family member who is supporting someone in an investigation or an inquiry, who are living that experience alongside a person, or a witness in an inquest who might be an emergency worker who is responding as a first responder, and then going through gathering, or colleagues who are working alongside you, who are trying to be professional in how they are presenting material, putting material together, operating in a way that is sensitive to the broader public perceptions of what that inquiry might involve, or presenting, as we're trying to do, in the most confidential and respectful way for clients' sensitive material. This is a really important landscape for, firstly, being ethical, secondly, being professional, and thirdly, being humane. Because through my career, I have sadly sometimes seen things done that have broken humans, and these experiences take time to recover. So it's not just about doing more good than harm. We are trying to talk about building a cathartic process where people are engaged in the legitimacy and sharing their information for good reason and for the benefits of the public, or sometimes where they don't have a choice, and they may have had a Schedule 5 notice or a legal requirement to provide that information, where we are just trying to professionally navigate somebody through what is a very difficult landscape. So for me, this is absolute basic. This is about, this is what good looks like, not just to achieve best evidence, but to be legitimate, fair, and have a just outcome for those people, even where they may not be happy with the ultimate decisions that people make. They've been part of a process that they can understand, but even that they have just physically sometimes been able to engage with. So sometimes the outcome may not be favourable, or findings may not be favourable for them. But just having the voice, the agency, and the participation in that process, for me, that is sometimes just the win, where you're trying to get people to have been able to participate in that. And through the trauma-informed methods that you and I have engaged, we have been able to do that with individuals who, in my opinion, may not have been able to, particularly in the long process, have managed that very difficult or navigate those very long and detailed and challenging environments.
And I guess that is, that I think for me, that's really sort of summed up our conversation in terms of what we're trying to achieve. And of course, what you've highlighted there is the consequence that if you don't do it, you either end up not being able to take valuable evidence and processes either fall apart or are not as complete as they could be, and therefore don't serve the judicial purpose that they were designed to, but also that it can be really harmful for individuals and also damages trust in those processes, not just for that person, but potentially for others as well, which is detrimental for all involved.
And can we also just mention that for our colleagues, we know that these environments can also be really challenging to work in.
Yeah.
And so there's a real drain of talent sometimes when people have worked on long inquiries, or they've become very jaded by the exposure to material or to situations. So I think we also owe it to each other to be better at building, and resilience is a loaded word sometimes, that it is not just about being able to come back or to bounce back from these challenges. It's to think forward and to have preparation, because we want to maintain the experience. We want to build good lawyers who have the emotional intelligence as well as the legal awareness to do this job. And so to be able to navigate these difficult scenarios, as they are often sometimes required to do so, is good for business as well. It's not just good for providing client care and service. It's good for building better, more informed, stronger lawyers who stay the distance and who build a stronger future for the firms and for the teams.
Which is what we all want to achieve, Rachel. Thank you very much for your time today. I think we could keep talking about this for at least another hour, but we'll leave it there for now. Thank you for your time.
Thank you. Lovely to talk to you. Thanks, Izzy.